We need to compensate those who've been harmed. But the question is how to do that.
It's clear that there are two different Mr. Trudeaus, one that talks about the importance of Indigenous relationships and the other that takes Indigenous kids to court.
Justin Trudeau has said no relationship is more important to Canada than the one with Indigenous peoples. Today, the federal government has announced it's challenging a ruling that ordered the feds to pay $40,000, up to $40,000, to each Indigenous child taken from their home and put unnecessarily into child welfare after 2006. The Canadian Human Rights Tribunal called the apprehensions, quote, willful, reckless, and discriminatory. So why is the government appealing this ruling? Seamus O'Regan is the Minister of Indigenous Services and a Newfoundland and Labrador Liberal candidate. He joins us now from St. John's. Hi, Mr. O'Regan. Nice to see you. Thanks for making time for us.
Good evening, Vashi.
The Prime Minister earlier today said that your government, and I want to quote him directly, agrees with the findings that there must be compensation. But the application filed by your government to the federal court is asking, and again I'm going to read it verbatim, for an order setting aside the tribunal's decision and dismissing the claim for monetary compensation. That directly contradicts what the Prime Minister said, so which is it?
So what we're trying to do here, Vashi, is very clearly say, look, we agree with the tribunal when it says that there's been discrimination and that there's been mistreatment. We also agree on the need for compensation. That's not an issue. The issue is the very prescriptive nature of the ruling. And we take issue, I mean, first of all, I think with how we identify survivors, how we identify those who've been victimized, and then how we go about with that compensation. And frankly, that's something that, if you look at our track record and during our time of government, is something that we can only reach at the table with our partners. And the issue right now is a timeline. The timeline to come forward to the CHRT with the parties to say how we are implementing this ruling is December 10th. We simply don't have the time to do that.
And there is no other mechanism that you are able to use in order to accomplish what you're talking about other than asking for the court to completely dismiss this ruling?
Well, I would say that the way to go about it is whichever government comes in, I think after this election, sits down with all parties. We would certainly be committed to doing that if we were returned as a government, sitting down with them immediately and discussing compensation amongst other things and other issues surrounding that. We would want to do that immediately. But the confines of this timeline are simply too stringent. Why
is the Canadian, in your opinion, the tribunal too prescriptive? I mean, the tribunal looked at all the evidence in front of it, looked at what happened to these kids, labeled it what it did, which was discriminatory, and came up with a figure it thought was appropriate. Why are they not the body to assign that figure? What is the problem with the figure that they have prescribed?
Well, because, and this is a stricture that I've followed during my entire tenure, as abbreviated as it's been as minister, is you talk to communities and you ask them where are the solutions, who are the survivors. I mean, I really do believe not in top-down solutions, but in bottom-up. And in identifying survivors, we have to be extremely careful, because as we identify survivors and abusers, we want to make sure that we have a process in place that doesn't re-victimize people.
What community is telling you that this decision is wrong, though? What community is telling you that it's too prescriptive?
Well, we haven't gone forward and asked communities, what sort of compensation are we looking for here? What are alternatives? I really do insist that we do that from the bottom up. This is an extremely.
Why didn't you do it before the ruling?
Why didn't we do what before?
Well, I mean,
talk to communities about
Yeah,
this?
like if you're saying now that you want to start talking to communities about what the appropriate amount is. We've known since 2016 that there was issues with the discriminatory nature of the treatment of these kids. Why weren't those discussions happening then?
I would say ultimately what you would want to reach after a discussion like that would be something along the lines of exactly what we've done with C92. We are going back to communities and giving them back what they should have had all along, which is control over their child and family services. And we co-develop that legislation with them. And we will arrive at local solutions with them. So, that just received royal assent, as many people know, and certainly our Indigenous partners know. And we've made it a part of our party platform to make sure that C92 is adequately funded. In the past, of course, what we've already done is doubled the amount of funding for child and family services to $1.2 billion. So we're well on the way to doing that. and the process that we have set up will ask individual communities how we move forward.
I'm not trying to take away from the process and the things that you have done moving forward, but this ruling is about kids from 2006 onward who were treated that way. This isn't about the way kids will be treated in the future. It's about compensating them for the way they were treated in the past. And this application very clearly states that your government wants a dismissal of the decision to compensate them. Are they, what message do you think that sends kids who were treated in this way?
It certainly weighs on me, what the message is. But the reason why I'm out in the media and speaking so clearly about this right now is to emphasize the fact that we want compensation. We want to have those discussions about compensation. That compensation is not the issue. But reaching a process that is fair, that is equitable, that is comprehensive, and frankly, that is safe is extremely important. We understand the urgency of doing it, and we want to do it with our partners. As we have in the past, we have a good track record on this. I mean, we've got a track record on day schools and on the 60 scoop, and we want to follow that process with our partners going forward. Your
government has also filed an application to stay, and in that, though you just said that this isn't about the amount of money, it says the payment of potentially $5 to $6 billion that may not be recoverable, and the outlay of significant human and financial resources, all to implement orders that exceeded the tribunal's authority. It clearly outlines, as part of the reasoning that this decision should be stayed, the amount of money the government would be required to outlay. So is that the issue? Is it the amount of money here that is the genesis for these applications?
I know that the Justice Department puts forward a number of different reasons when we file for a review like this, but I can tell you what's top of mind for us, and as the Prime Minister mentioned before.
The Justice Department is the federal government. That is you. The government would have to condone everything that the Justice Department submits here.
Right, but if I could just finish what I was saying, the real issue here for us is time. The ability for us to reach an agreement on this ruling with our partners by December 10th, take into consideration that we are in the middle right now of an election campaign, is just not something that we can do in a comprehensive or an effective way. And we know that. I mean, this is a ruling that we received 3 days before the writ was dropped. It is extremely difficult in that very, very tight and prescriptive timeline to I think, reach an effective solution. And that's the conclusion that we drew. Having said that, we are committed to compensation, and we are committed to finding a process with partners, and we'll do that, God willing, if we form the next government, and we're able to do that.
Could the federal government just have asked for an extension rather than a dismissal?
No, unfortunately.
That was not a mechanism available at all?
No, this is the mechanism, unfortunately, the only mechanism that we could use. And so, again, in order to be able to reach that fair and safe, equitable resolution, this is what we've had to do.
So if this is dismissed, are people who are affected by this ruling, kids who are affected by this ruling, supposed to just take your word that if you form government, you will sit down and work out some kind of compensation? I mean, there will be nothing legally binding you to do so.
No, but look what we've done in the past, whether it be the 60 scoop, whether it be day schools, whether it be co-developing legislation on child and family services, and now in the process of implementing that and funding it properly, returning child and family services back to communities, back to Indigenous communities, so that they are in control of this now, because Lord knows we certainly haven't done a very good job of it, that's for sure. And that commitment to compensation is very real. We have a track record on this, doubling the child and family services budget to $1.2 billion, and an overall new budget for new programs, services and infrastructure for Indigenous peoples of $21.4 billion.
Surely you can understand how Indigenous kids would have a hard time believing the state in something like this, right? No matter what your record is, but anyone who occupies that position. And also, what about if you don't form the government? What if the Conservatives form the government, who have already expressed that they too wanted a judicial review on this? There will be nothing legally binding them to compensate these kids because your government has asked for a dismissal, right?
Because there would still be concerns, regardless, that we would have, whether it be for us or for any future government. It would be concerns about exactly how we identify in a very safe way who those survivors are. It would be about not only identifying the survivors and abusers, but also the scope and range of who, in that timeline that you cited, whether it's 2000 or previous to 2000. We would want to make sure that it's a process that was as effective as the one we've used for day schools, and the one that we've used for residential schools, and the ones we used for the 60 scoop. Those questions would still remain.
But now it's possible that because of this request to dismiss this decision, the next government will not be bound to make any kind of compensation. The next government might not make the kind of commitment that you say that you're willing to make, right? Because you filed this dismissal.
It is so important that we get this right. It is so important that we sit down with partners and work with them on a ground-up solution.
Okay, I'll leave it there. Thank you, Mr. O'Regan. I do appreciate your time this evening.
Thank you, Vashi.
That's Seamus O'Regan, Minister of Indigenous Services and, of course, a Liberal candidate for Newfoundland and Labrador.
No, we agree that we need to compensate them. We absolutely agree there needs to be compensation. The question on how to do it requires conversations with partners, with communities, with experts.
So why didn't you ask for an extension instead of asking for a judicial review?
The decision by the Human Rights Tribunal came down mere days before the actual writ got dropped. And the Canadian Human Rights Tribunal expects us to bring in a plan of action by December. That is simply not practical, not possible, given the electoral context we are in. That is why we need to have more time to be able to have these conversations.
The federal government is challenging, as you heard there, a ruling by the Canadian Human Rights Tribunal, to compensate First Nations kids affected by the underfunded child welfare system on reserves. The ruling in September ordered the federal government to pay each child affected up to $40,000. We're back with the Power Panel. The CBC's Olivia Stefanovic is joining in alongside Jason Markisoff, Vicky Machama, Jamie Poisson, and Aaron Wary. I'll start with you, Olivia, because you've been covering this all for a long time, but especially today. Explain what basically what the federal government decided to do today.
Yeah, so basically the Attorney General of Canada filed an application with the federal court seeking a judicial review and a stay in this ruling by the Canadian Human Rights Tribunal. And it's such a significant ruling because it orders Ottawa to compensate each First Nations child $40,000, which is the maximum allowance for this type of ruling. And this could actually cost the federal government over $1 billion. It could actually cost billions of dollars. So it's not cheap. And the reason why there's been a complaint before the tribunal is because the federal government has been underfunding the on-reserve child welfare system. So this has been going on for years, and the people who made this complaint to the tribunal actually filed this back in 2007. So this has been going on for more than a decade, and finally now the federal government has a chance to compensate these children, and it's again trying to fight this.
And was it a surprise that they ended up filing this appeal?
Well,
the challenge?
No, not exactly, because the federal government has been fighting ever since this complaint came forward. So since 2007, Ottawa has been in court with the Assembly of First Nations and Cindy Blackstock's organization, the Caring Society, to fight them on this. Now, the federal government says that they are still open to the idea of compensation, as you just heard from Justin Trudeau there, but they haven't said, nobody has said that they would offer each child $40,000. So that still is a question.
Okay, Vicky, let me ask you, what did you think of the decision by the federal government today? I know that it's not necessarily a surprise given their past behavior on this file, but given it's in the middle of an election, I know they had a deadline. They had to file the appeal today, and given the rhetoric that we've heard, especially from the Liberals, on the primacy, the importance of reconciliation, what's your reaction?
I think it's a really unfortunate, if not. I mean, I know hypocrisy is kind of the watchword of the week, but this one I think it has some significance and some weight to it, which is to say, Justin Trudeau and the Liberal government really rode in on making a very different and substantial approach on Indigenous issues, up to and including the Canadian Human Rights Tribunal. However, since the 2016 decision, there have been 7 non-compliance orders. So the notion or the excuse that it's because of an electoral cycle that the government can't put into place plans that it was legally mandated to do back in 2016 is, kind of falls apart. But then when you look at the appeal, they're not just asking for a judicial review, they're actually looking for the vast majority of the Human Rights Tribunal's decisions to be dismissed, up to and including compensation. So while they're saying out loud that there might be compensation, they're also communicating on legal documents that they do not necessarily want to follow through on compensation. I also think there's a legal strategy to this, which is to say they're facing down a number of lawsuits, up to and including a $3.3 billion class action lawsuit. And so for them to allow, I guess for the government to allow this sort of legal logic that the Human Rights Tribunal case provides, that means further payouts. And I think we've seen, many more cases like this exist in our historical record, but also to this present day. And so as a legal strategy, it's an attempt to mitigate future cases, but I think as a political moment, I think it's a real failure of the Liberal government's plans around reconciliation, and I think if Indigenous people look at it and decide that this government's not for them, they wouldn't be wrong.
It's difficult to rectify, Jamie, what the Prime Minister or what the Liberal leader said in the clip that we played, and what Mr. O'Regan said at the beginning of the show, which was very much that they are, they were insisting that they are committed to compensation. But if you read, those comments came after we were able to look at these applications, and there are many, many instances in the application where they detail that they would like that compensation order, that decision dismissed.
Right.
What's your impression?
So, I think what we're looking at now is the evaluation of a government's record, not a government running on sunny ways. And, if you just look at this issue alone, which to so many people in this country is so incredibly urgent, like for so many people in this country, this is a modern day version of residential schools. I immediately thought of this APTN investigation, which just recently came out. I just want to give these numbers. So 102 Indigenous children connected to child welfare died between 2003 and 2017. Almost half of those deaths happened in the 2 years it took the Trudeau government to increase funding after the initial tribunal ruling in 2016. And that found that they had, the government had purposely discriminated against First Nations children. So, I think that this decision, and I know Cindy Blackstock is with you here. She can speak to this so much more eloquently than I can, but I think that this is a decision that will be very hurtful to a lot of Indigenous people in this country.
Jason, the government insists, like I said, that they are committed if they do, or the Liberals say if they form government again, to sitting down and working out compensation. They really insist that they're not against compensation. We know that Conservative leader Andrew Scheer said that he would also ask for a judicial review of this. The NDP and the Greens, on the other hand, say that they would comply with this order. What's your reaction?
Well, this is where things really pinch for the Liberals, because they won election in 2015 saying they'd be so much better for Indigenous issues, Indigenous rights than the Conservatives. And here you have the day after Scheer says he'd appeal this ruling, the Liberals coming out and actually appealing that ruling. But on the compensation thing, I want to bring it back to something that Vicky was very good to bring up, the class action suits. The Liberals and the Liberal government and the Conservative government before it have a very long track record of compensating to the tune of several billions of dollars. Past misdeeds by the Canadian government on Indigenous people. 60 Scoop recently, the residential schools. Just a few weeks ago, there was a settlement on residential day schools. But in those cases, it was class action settlements where the government lawyers can go and sit down and hash out the compensation. In this case, this was the tribunal, the Human Rights Tribunal, handing down their decision. And I can imagine that as a government, be it Conservative or Liberal, they would want to be negotiating the terms and amounts of the settlement, not having that ruling handed down. I think that is the government response. That doesn't really sell well, though, in a political election.
Yeah, that's a really good point. The word that Minister O'Regan used was too prescriptive, that it was prescriptive. And then if you look in the documents, jurisdiction is an issue as well. It appears, and I'm inferring, they are worried about overreach of the tribunal. But that said, there's a message that this decision sends.
Yeah, and I think that's I think on this particular on this file and the proceedings at the Human Rights Tribunal, and arguably on the entire issue of reconciliation, the Liberals have kind of gotten caught in this position where they say, we agree with the broad principles, we want to do something, we still want to talk about the details. And that is those are two messages that are hard to carry at the same time. I'm sure there are voices within the Federal Justice Department that say, look, the government has a responsibility to defend itself and to press it, make its case, make its arguments, et cetera, et cetera. But again, you get stuck in that position of saying, well, we want reconciliation, but we're kind of going to haggle over the details. I think it's this government can point to a bunch of things they have done on reconciliation and say, we've advanced this file. We've
spent a lot of money.
We've invested tons of money. We've made real progress. But having started from the promise of reconciliation and a renewal of the nation-to-nation relationship, they get marked back for all the ways they haven't quite lived up to that. And that is, so in a case like this, coming in the middle of a campaign, it's very hard to square that from a political standpoint with what they've promised, with what they're supposed to represent.
Olivia, what do you think? Last word to you. What message does it send?
Well, from people I've heard, I mean, they are hurt, and what they're most worried about is what message this sends to Indigenous kids who are apprehended, have been apprehended. There are actually more Indigenous children in care now than there was at the height of the residential school era. So that just gives you the scope of just the numbers of this issue. And this doesn't look good right now for them. However, we have to wait and see what the Liberals are going to do, of course. But right now, this isn't something that they're taking lightly.
Okay, thanks a lot. Thank you, everyone. Thanks to our power panel this evening, Jason Markusoff, Vicky Machama, Jamie Poisson, Olivia Stefanovic, and Aaron Wary.
Thanks, Ashley.
More reaction now to the federal government's decision, as we were just discussing, to challenge a ruling that ordered the feds to pay compensation to each Indigenous child taken from their home and put unnecessarily into child welfare. The government says it needs more time to figure out how the compensation would work. Cindy Blackstock is the executive director of the First Nations Child and Family Caring Society of Canada. She joins us now. Hi, Ms. Blackstock.
Hello.
Nice to see you. Thanks for doing this. Really appreciate it. So the government says that it's not an issue with, or the Liberals are saying it's not an issue with the money or compensation. It's that they need some more time to figure out how it will all work. Do you believe that?
No. And here's why. This case was filed in 2007. They were aware we were seeking compensation since that time. In 2016, the tribunal found against them and said it was taking the issue of compensation under reserve. For the last about 2 years, we have been trying to sit down with the federal government to talk about those details, and the federal government has refused to mediate. They said the only way to deal with this is to litigate. So we litigated it. And during the arguments, Canada was saying two things. They were saying, number one, there's no evidence about individual harms to children in the record, and that's completely false. We've seen that kids have actually died during the time when this case was going on, and many hundreds, if not thousands, were separated from their families. And then the second thing they said, which was really unbelievable, is they said, well, if you wanted to prove individual harms, you ought to have brought the children themselves to testify. Can you imagine, Vassie, bringing 5- and 6-year-olds to talk about what it's like to be separated from your families? But that was the government's position. And since that ruling, we've continued to reach out to the government, but they haven't responded. So they've had every opportunity. It's been them that has shut the door on us in terms of working out those details. So for them to say they want to talk with partners, well, they haven't been at the table.
They say that they're referring specifically to the decision in the beginning of September that awarded, and I think the term that, and I mentioned it in the last segment, that Minister O'Regan used was prescriptive, that the decision by the tribunal was so prescriptive in that it said kids who were subjected to this could be awarded up to $40,000. What's your take on that?
Well, this Canadian Human Rights Act was actually constructed by Parliament itself, and the level of damages that the tribunal was awarded was actually established by Parliament. Canada only gets nervous about this because the award is made against them. I think that their concern should be about these children and these families who have been discriminated against. And I have heard from so many families who, since that ruling, said for the first time they felt someone acknowledge the harm they experienced in losing their child or having their child put into care, or youth in care who said, finally, I can go to university. And now the federal government's sending a message to say, no, you know what, in our legal drawings, the irreparable harm is not to these children, not to these families, it's to the federal government, even though the compensation would represent less than 1% of the federal government's budget.
If the federal court does dismiss this, is there any mechanism that you can see by which what the Liberals are promising, which is that they would negotiate some kind of compensation, could actually happen? Like, is there any way, in the absence of this decision, to make that happen?
Well, a couple of things. We have to go back to court on on October 23rd, 2 days after the election, to deal with Canada's request here for judicial review. It's not certain what the federal court will decide. And then, of course, we could appeal that decision to the Federal Court of Appeal and on to the Supreme Court of Canada. We're certainly committed to doing that, even though Canada wants court costs against us. We feel that we have to stand with the kids. Canada could at any time pick up the phone and say we want to offer a settlement, but so far they haven't done it. And frankly, my view is that they should honor this ruling, and then they should begin a process of trying to resolve that class action. The reason they're being hit with these two types of judgments is that they failed to reform the department after the residential schools to make sure the 60 scoop didn't happen. And then when the 60 scoop happened, they didn't reform the department so that this willful and reckless discrimination didn't happen. So it's now time for them to get an additional penalty and provide some level of measure of justice to these kids.
Can you help our viewers and our listeners understand what exactly this decision was about, what these kids were subjected to?
Sure. Like, a lot of folks don't know that the federal government funds all public services on reserve, and whereas the provinces and territories fund it for all others. And dating back at least 112 years, the federal government has known that it's underfunded all public services, and particularly child welfare services. So when families are going through trauma from residential schools, there's usually services in place to try and stabilize the family so kids can stay safely in their homes. Those services weren't funded. And so we said that was discriminatory. We also said the fact that Canada doesn't allow children to have equitable access to other services they need, like health care and things like childcare, that was discrimination. The tribunal substantiated that, and they actually found in that decision that Canada's discrimination was not only linked to the wrongful separation of First Nations kids from their families at higher rates than a residential school era, but also in some cases tragically to the deaths of children.
Okay, I have to leave it there. I really appreciate your time and your insights today, Ms. Blackstock. Thanks for being with us.
Thanks for having me.
That's Cindy Blackstock, Executive Director of the First Nations Child and Family Caring Society of Canada. Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.